Now, Dan has just done a really good video breaking down all the evidence in the Tommy Robinson defamation case. And that's given me an opportunity to chat about how judges assess evidence generally in civil cases. And this is one that's actually quite useful for anybody who finds themselves embroiled in litigation, because if you know this will assist you in how to prepare your own case so that you put forward the most persuasive evidence possible. So what I'm going to do is I'm going to talk about something called the Gestmin Principles. That's after a case called Gestmin and Credit Suisse, which set these out. And they have pretty much been adopted in civil courts generally. And it's all to do with how we assess memory and how memory actually works. It's one of these weird things where finally the justice system is interfacing with the psychology and the real world of how people actually process information. And just once again, I'd like to say thank you for all the comments. I'm a bit slurry today, but I was in the pub last night, so that might have something to do with it. Some friends dragged me out, and I have to say just being out and about chatting really helped. Although I was in a Cornish pub full of farmers, so we got talking about the budget and the effect on cauliflower growing. It's all very fascinating. But what's the starting point with Gestmin? Well, it's effectively that human memory is fallible. I've actually made some notes because they're quite complicated. Everybody knows that human memory is fallible. But as they acknowledged, the legal system has not sufficiently absorbed the research into the nature of memory and the unreliability of eyewitness testimony. And we're not always aware of the extent to which our own memories are unreliable. And we often believe our memories are more faithful than they actually are. And so what are some common misconceptions about memory? Well, there are two main ones. One is that the stronger and more vivid our feeling or experience or recollection, the more likely the recollection is to be accurate. And the more confident another person is in their recollection, the more likely their recollection is to be accurate. But judges are specifically warned about this. They are told that just because somebody seems very confident and very sure of themselves, that doesn't necessarily mean they're telling the truth, as they believe it, any more than, you might get a very nervous, hesitant witness who seems a little bit sort of like shifty and, potentially unreliable and not quite sure, but their memory might actually be better. So judges are specifically told, it's all back to this demeanour thing. I mean, it's rather strange that we do accept that demeanour is something that judges can take into account, and indeed juries. But there's a problem with that because, we base our experiences on our own experiences and how we behave. And, there's been some, to go back to the Letby thing, there's an argument there, it's a bit like the Lindy Chamberlain case. Were the jury prejudiced against her because she wasn't reacting how they would assume, quotes, a normal person would react in those circumstances? The fact that she was hesitant in her evidence and she wouldn't come into court and things like that. So we talk about the faulty model of memory as a mental record. I can summarise this very quickly by saying memory is reconstruction, not recall. It's not like we go to a database and we've got it all recorded there and it's hyper accurate. Every time we think about something, we are reconstructing it. And often those reconstructions are not accurate. Underlying both these errors is a faulty model of memory as a mental record which is fixed at the time of the events and fades over time. But memories are actually fluid and they're malleable. They're constantly being rewritten whenever they're retrieved. This is very true of what we call flashbulb memories. It's misleading because we talk about that as if it's like a camera has taken a picture and recorded it forever. But that's not how memory works. External information can intrude into a witness's memory, as can their own thoughts and beliefs. And this can cause dramatic changes in recollection. And events can be recalled as memories which did not happen at all, or which happened according to someone else. It's called a failure of source memory. Now, just to go off on a tangent, as I've mentioned before, I used to do a lot of use of force type stuff, when either civilians, but often like police and military and people like that, when they had to use force. And those incidents are very, very traumatic. And there's lots of evidence about just how the fallibility of memory there. I mean, you get all these weird effects. You get like tachypsychia, that's where things slow down. I don't know if you've ever experienced that. I had that once in quite a bad vehicle smash, where we were in in my roadie days, where the tour bus flipped over. And I distinctly remember that it just happened in such slow motion, had time to sort of brace and grab onto things. It was really, really strange, because even though the incident must have happened in seconds, it felt like you had ages to prepare for it. And this is something that crops up a lot with traumatic stuff. I mean, obviously, use of force is one, but, lots of incidents are traumatic for people. I mean, there's a famous case once of somebody who'd been in a shooting incident, and they said my gun wasn't working, but I remember that the assailant was throwing beer cans at me. And obviously that didn't happen. And they got the person to describe the beer cans, and they said, they were sort of like bronze in colour, and they had Federal written on them. And they realised what the person was actually seeing was the ejected cartridge cases from their own firearm. But that had gone in their memory as somebody throwing things. And we talk about shot count and recall. I mean, people can never remember how many shots they fired. They always underestimate it. I mean, they always say like they shot 2 or 3 times, even if they shot emptied the magazine. And also memory comes back. I mean, a really common question that we use in advocacy is, where we're looking at an inconsistent previous statement. Somebody said something earlier and now they're saying something else. And we actually, because of the way we prepare cases, we always say, you don't want any surprises in a case. We never ask a question we don't know the answer to. So we'll look at the statement and say, right, that's the answer we want. But then somebody will give a different answer. So we'll say, well, you would agree, wouldn't you, that your memory of this situation would have been better closer in time to that event than it is now? And people, yeah, absolutely. But that's simply not true. It's very, very common for memory to come back in stages. I mean, quite often it's a triggering event. People after an event might not be able to remember anything, and then they'll hear a car backfire. Or it could be something as simple as like a particular smell, and all of a sudden it'll be like, ping, more memory will come back. And that's something that we reflect on. Even in non-traumatic events though, just commercial disputes, the memories after the time, they can actually get better over time. But memory is especially unreliable when it comes to recalling past beliefs. What were you thinking at the time? Memories are revised to make them more consistent with our present belief. And studies have shown that memory is particularly vulnerable to inference and alteration when a person is presented with new information or suggestions when their memory is already weak due to passage of time. I mean, what does that actually mean? Well, it means that you have come to a conclusion now, because don't forget, trials take place years after the events quite often. And even if, you go through litigation and you prepare witness statements, it's very rare that you sort of prepare them, immediately, at the time. Because a lot of the time you don't even realise there's going to be litigation. It's only years later that you realise, a contract went wrong or somebody was negligent. So it's not like you're making contemporaneous notes. I mean, again, just as a tangent, if you actually make contemporaneous notes, you can actually use those to refresh your memory in court. I mean, the classic example is the police officer's notebook. And there's like a little routine we go through. Now, officer, did you make notes of this? Yes, I did. When did you make them? I made them like shortly after the incident. Well, were the events fresh in your mind? Yes, they were. Can the officer refer to, their notebook to refresh their memories? Because, it's this rather weird thing that we don't actually let witnesses have their witness statements. That was the old rule. I mean, now it's all changed, of course, because evidence in chief in civil cases isn't generally given orally. People just adopt their written witness statement. So it's like, could you turn to page X of the bundle? Yeah, do you see a statement there? Yeah, flick forward a few pages. Is that your signature? Yes. Are you signing to say this is all true to the best of your knowledge and belief? Yes, it is. Do you adopt that evidence? Yes, I do. Wait there may be some cross-examination. That's how we do it now. But we, generally speaking, don't allow witnesses, even when they're being cross-examined, to sort of like be reading from their statement. And as judges have commented, trials are not meant to be a memory test. They're meant to be, well, we always say this, trials aren't a search for the truth. They're just a search for the best evidence. But, when it comes to this sort of thing, we do now allow witnesses to refresh their memory from statements and documents. But again, that in its own self, that adjusts how they think about something. Before I ask you this question, can you turn to page X of the bundle and read that email? Right, now having read that email, I'm going to ask you some questions. Well, are you really remembering what happened, or are you just basing it on, what you've just read in the email? As I said, the process of civil litigation itself subjects memory to biases. The process of civil litigation, because witnesses have a stake in a particular version of events. I mean, obviously, if you're one of the parties, you really do. But even when witnesses come along and they're not the parties, but they're there to support one side or the other. I mean, this is why I've always said in my standard advice to witnesses, actually, don't try to do that. Don't try to assist or help one side or the other. Just come and give the evidence as best you can. It's the lawyer's job to try and win the case for the client. It's not yours. So you just come along and do your very best. And I always say, don't guess. If you don't know an answer, just say you don't know the answer. Don't give us the answer you think we're looking for, even if you give the answer that you actually believe, even if you think, oh, actually, that doesn't really help my friend out. And the procedure for preparing for trials, that has a really big influence on, how memory works. A witness will ask them to make a statement, but that'll be a long time after the relevant events. And quite often, statements are drafted by lawyers. And the lawyer has a sort of we're conscious of what are the issues of the case. Now, I've said before, we saw this in the post office, the standard answer to make your evidence completely pointless as far as the judge is concerned is to say, my lawyer wrote this. Because the whole point of witness statements is they're meant to be in the witness's own words based on what they know. And you're supposed to put all the sources of your belief in there. If it's something you witnessed personally, you say that. If it's something you heard from somebody else, or an inference you draw from something else, or a memory, something you wrote having checked some documents, you're supposed to put all that in there so the judge can assess, well, how reliable actually is this? I mean, you probably see I'm building up to basically, are witnesses actually any use at all in court? But the documents, they include the pleadings, all the other argumentative material. I mean, the pleadings are things like the statements of case, the particulars of claim, the defence. That's the case theory being put forward. And if the witnesses see those, they adapt their evidence to support that narrative. But statements go through lots of revisions before they're finalised or settled, as we're to use the technical term. And then years or months later, when the trial comes, we say, could you reread your statement and all these documents before giving evidence in court? And the effect of this is to establish in the mind of the witness the matters in the statements, whether they be true or false. And this also causes the witness's memory. It's based more and more on the material and later reinterpretations rather than the original events. So it's a very artificial process. And there's a difference between reconstruction and recollection. Witnesses, we often ask them in cross-examination the difference between reconstruction and recollection. But, these questions are misguided. There's a presumption that there is a clear distinction between recollection and reconstruction. And that, remembering distant events, it's recollection. But it's not. As we said, it's reconstruction. And questions like that, they disregard the fact that the processes are largely unconscious, and the strength, vividness and apparent authenticity of memories, again, it's not a reliable indicator of whether they're true or not. So how do judges interpret all this? Well, one particular judge, the guy who actually did all this, he was very concerned with commercial cases, but this is a universal applicability. And he said, well, actually, we don't really place that much reliance on witness recollections of what was said, especially about meetings or conversations. Factual findings are based on inferences drawn from the documentary evidence and the known probable facts. I've said before, judges never like to accuse anybody of lying. It's very rare they'll say, you were lying, this witness was lying. They'll say, I prefer the evidence of. But the way they usually do it is they will assess the evidence the witness is given, first of all, is it internally consistent? Does it make sense? But they'll assess it by reference to contemporaneous documents, because the argument is that before you realise this was all going to kick off and end up in court, the emails at the time, your notes in your diary, they are not written, with the idea of persuading somebody one way or the other. They're more likely to be very, very neutral. So a judge will look and say, well, you're now saying that, but this email indicates at the time you were thinking something different. And this is something that, with the Tommy Robinson thing, to get back to that, get a bit of clickbait in there, people say, well, there were all these witnesses and they said this and they said that. But it was like, but it was demonstrably shown that the records showed that people couldn't have been where they were claiming to be at the time. Now, they're not necessarily suggesting anybody was lying, because like I say, this was years after the event, and they've, formed their own ideas as to what happened based on what the litigation is now about. But that's the reason you can dismiss a lot of witnesses, because you can just say, well, yeah, you're all coming here, you're all saying this, but we can prove that actually you weren't there. You weren't in the room with that person. And I know people suggest, oh, documents have gone missing and it's all a cover-up. But, there's nothing to suggest that. I mean, in the absence of showing that records have been tampered with, if they'd just been prepared in the normal course of business or administration, judges tend to go, well, why would anybody do that? At the time, there was no reason to prepare for a cover-up. I mean, don't get me wrong, sometimes there are. You get cases where people, it's very, very common in commercial stuff where people are overcautious, and they will always, when they send internal emails, they will copy in the legal department, because material prepared in what we call contemplation of litigation, whether there may be either a claim you want to bring or a claim may be brought against you, if you're actually preparing that material in consultation with lawyers, it's non-disclosable. So there is a little bit of a trick there where people will just copy in legal, just to make sure that it is actually non-disclosable. I mean, I'm not recommending you do that, but that's very common in sort of business. Now, this doesn't mean that oral evidence serves no purpose whatsoever. I mean, there was a thing after Gestmin where there was a bit of a trend of judges just to say, I don't really care what the witness statements say. They give a bit of a background flavour, but I'm going to do this all on the documents and all on the contemporaneous documents, because by the time everybody gets to court, everybody's got a dog in the fight. So how reliable is it? But, the utility of witness evidence is often disproportionate to its length. I mean, you get all these big lengthy statements put in loads of detail. I mean, I'm a big believer in, I'm a minimalist in court. Keep it as simple as possible. I mean, this is just good advocacy anyway. You're trying to sell a narrative. Barristers are fundamentally storytellers. We're trying to sell a story, and we need that story to be as concise and simple and easy to understand as possible. And we always say your theory of the case, your argument as to this is what happened, it has to comport with the law and the known facts. But also, the key thing I say to the young advocates is, it has to make sense. It has to be something that a judge or a jury go, well, that fits in with my real world experience. That's understandable. That's how people behave. I mean, sometimes you do have a case where you'll say you have to exercise some mental gymnastics to arrive at the conclusion I want you to arrive at, because life is complicated. But generally speaking, if it's something that is easy to swallow, that just makes sense, it is more persuasive evidence. I mean, the key point is to remember, you've got to avoid the fallacy of supposing that because a witness has confidence in their recollection and is honest, evidence based on that recollection provides a reliable guide to the truth. It just doesn't. And like I said, people aren't necessarily lying. They are just forming these memories, which aren't real memories, to support what the current narrative is in the court proceedings. And judges are becoming more and more aware of that. Although there is a caveat, because, like I say, after Gestmin, there was a bit of a tendency to sort of almost disregard oral evidence. But in another case, a judge said, over-reliance on Gestmin is fraught with danger, because, some people do remember things, especially if, it's been a very traumatic event, then it's like, yeah, actually, that is very stuck in my mind. I do remember, I might remember all the details, I mean, this is actually a little cross-examination trick we do. The example we give is, say somebody wants to prove they were at a particular football match. You know, it's an alibi or something. And you say, right, you were at the football match. Who won? Who scored? Oh, well, something United, they won 4-0 and the scorers were X, Y and Z. Well, what does that show? That shows you can read a newspaper. So the questions we will ask is, what colour were the stadium seats? How much were the pies? Where are the toilets? That's the sort of background detail that, you know, makes things more reliable. And sometimes we'll do that. Like, you know, I said, we don't want to get too bogged down in detail. We just want the basics. But that's a good way of testing evidence, is to see what else can people remember about that. I am adamant this meeting happened. You know, this person said that and this person said that. Well, where did you have the meeting? What was the room? Where you sat down? Where were the seats? You know, what colour were the curtains? That sort of thing. But like I say, this is how judges assess evidence in civil cases. So when you read something, go, well, I don't understand, because one party had 20 witnesses all saying the same thing and the other party just turned up with a couple of emails and a couple of school records. How did they win? Well, it's like, well, you know, when you're using these principles, you know, the records that were prepared at the time, before people realised this was all going to be a massive fight and people were going to be arguing about this, they just say, well, that's more reliable, because at the time there was no motive for falsifying those records. I mean, sometimes you like to say, you know, that might be an issue in the case. These records were falsified. But this is something to remember. So when you're, you know, if you find yourself in a case of your own, try and get as much background material as you can. Try and get as much of the contemporaneous material. You know, get your emails there, get your letters in, get your documents, because, you know, when people say, oh, well, I'd always been, you know, complaining about this car, or I always knew it was unreliable. Well, no, because here's an email saying, thank you for doing such a good job fixing my car, or something like that, or thank you for doing such a good job fixing my kitchen extension. Or the contrary, you know, we do have this where you have emails sort of going, I'm not very happy about this, and oh, can you just come round and do this? You know, can you just sort this out? We've got some snagging issues. And again, these are probably written without any, you know, contemplation that you're going to have lots of litigation about this. But these all provide background. So there you go. So as always, you know, hope this is vaguely useful, vaguely informative, vaguely accurate, but also something you can apply yourself if you ever find yourself in court. But also, when you're wondering why judges have made decisions they do, I mean, and do go watch Dan's rather excellent breakdown on that particular case. This hopefully will inform you as to why a judge may have made certain decisions that they did. So there you go, and thank you. And like I say, once again, thank you for all the sympathy about this thing. I actually am feeling, it does seem to be getting better and better, so hopefully I'll be a little less slurry for you, and I won't have to wear these glasses to, you know, because I can't quite shut my eye at the moment. And I'm also inside today because it was just too miserly outside, although I think I will go for a walk now. I mean, the camera might not be waterproof, but I very much am.